Thank you, Madam Chair. Madam Chair, I have an amendment that I would like to introduce, but there's a certain volume to the amendment, so I'll perhaps wait until the pages have had an opportunity to distribute it in full, and then I'll discuss both the subject matter of the amendment and the actual gist of the amendment. No, sadly, it does not include pictures and no graphs either for the answer to the question of the interim leader. But, Madam Chair, the amendment which is now being distributed is somewhat voluminous. As you noted, it's 4 pages long, and that's not typical for an amendment, but in this case, the amendment of that length
Honourable
was required.
Member, if you could just stop for 2 seconds just to make sure we have the appropriate... Yeah, please go ahead. Honourable Member, please go ahead.
We're good?
Go ahead. Yeah, you're good.
Thank you.
Thank you.
Madam Chair, this amendment is an attempt to correct what I felt was one of the most egregious parts of the bill, and I mentioned it in the debate on second reading, and I mention it again here now. During the course of our committee's discussion, and specifically most of this discussion happened on September 9th, the government members on the committee put forward the notion that the state should become involved with the process of how political parties decide who their candidates are. And that is something that the state has never become involved with before. And while some may view the placing of both contribution limits and spending limits on nomination contestants as being a small step or a small entry into the overall process of choosing political nominees that represent political parties in our system, I would suggest that it is representative of something considerably more onerous and considerably more dangerous to our democratic system. Political parties should run relatively independently of the state, and government should not become directly involved with the internal operations of political parties. That principle was in fact upheld in a decision which was quoted by the Chief Electoral Officer on September 9th in our committee hearings, in which he quoted from the 2007 decision of the Ontario Court of Appeal in Longley versus Canada, and I'll quote this again. It deals with discussing the Chief Electoral Officer's restraint from involvement in political party affairs, and specifically states that any regulatory regime governing political parties must interfere as little as possible with the autonomy and internal affairs of political parties. Now, Madam Chair, I object to this particular inclusion of nomination contestants into the EFCDA on 2 bases. One, on principle. I don't think the state, I don't think the government should be getting involved with how political parties run their internal operations. We've talked at length in this House how there are different models for how political parties operate. The NDP operates on a centralized model. That is fine. The NDP has a system whereby one person is the president of 35 different constituency associations and the CFO of 36 different constituency associations. I don't think that's a model that I would necessarily support, but that doesn't really matter what I think. What matters is that that is the way they choose to run their party, and they have the right to do so. And I especially don't think it is the right of the state to decide that that shouldn't happen. If that's how they decide to run their party, that is just fine. But by the same token, Madam Chair, other parties may decide to run their parties and run their nomination processes completely differently. And for the state to specifically get involved with fundraising by nomination contestants, for the state to come out and say that we are going to set specific spending limits for nomination contestants opens the door to the state becoming involved in a wide variety of other parameters that are decided by political parties in terms of how they decide who their nominees are going to be. I can say that, for example, in the Progressive Conservative Party, our different constituency associations all have specific guidelines and rules that they abide by in terms of advertising requirements, in terms of a deposit that is required to be put down by a candidate in order to help defray some of the costs of running a nomination meeting, the requirements for the number of ads and the number of signatories they need for nomination papers. There are a wide variety of different parameters that are involved in the nomination process. To become involved in any aspect of that, to me, is a gross overreach of the state into the internal operations of a political party. Personally, I think that should send a shiver down the spine of anybody who is interested in free and democratic society. Now, I try to avoid, Madam Chair, wherever possible, some of the hyperbole in the description of the NDP in terms of them being so far to the left side of the political spectrum that they could be in any way equated with some of the more leftist totalitarian regimes that we have seen in the history of the world. So I'm not going to go to that extent. I'm not going to go to that extent. But, Madam Chair, I am really concerned when we see a government that sees absolutely nothing wrong with delving into nomination contests. And in fact, during debate on this issue on September 9th, the honourable member for Edmonton McClung, who was in attendance on that day at the committee meeting, made a passionate argument as to why it is indeed the state's business, and that it is indeed the state's business to get involved right from the earliest stages of the electoral process. I think that is something we should all be very, very concerned of. Because if they can get involved with the nomination process in terms of spending limits and in terms of donation limits, how long before other parts of the nomination process are dictated by rules from the state? I think that's a question that we should legitimately ask ourselves. So, to begin with, on principle, I don't feel the state has any role whatsoever in terms of regulating or legislating nomination contests. That is an issue that is completely up to the political party, not up to the state. And different political parties will decide on it different ways. Let's perhaps turn the tables on this. Before the last election, many of the nominees that ran for the New Democratic Party did not face nomination contests. In fact, they were appointed or acclaimed. What if in the next legislature we were to decide that no, all candidates, all nominees should have to face a contested nomination, and that acclaimed candidates would be disqualified? What if we decided to do that? I think that that'd be completely overreach. I think that'd be completely out of bounds, and I'd be a little upset myself because I was acclaimed for both of my nominations. Nonetheless, the fact remains that it is a complete and total overreach on behalf of the state. The state has no business in telling political parties how they are to choose their nominees. None. Once a person becomes a nominated candidate, then the state has a right to get involved with ensuring that there's that there is equity in the playing field between the various representatives of different political parties. But up until that point, that is the sole purview of the political party, and the state should have no involvement with it. But my second objection to this is one of practicality. And that is that I asked specifically the Chief Electoral Officer at committee whether this is something that they currently have the resources to take care of, whether they currently have the resources within Elections Alberta to take care of the extra workload that would be required. And the Chief Electoral Officer unequivocally said, no, they don't do any of this right now. This is completely new. They don't have the resources to handle this right now, and it would require the hiring of additional staff. And I said, well, how much? How many additional staff? And his estimate that it would include 5 new full-time equivalents at a cost of about $350,000, new office space, that it would require developing a new platform for the reporting of these expenses, and also for the monitoring of these expenses. So, to start something that would require additional expenses at a time when we're running a close to $11 billion budgetary deficit seems to be very counterproductive, especially when we have to ask ourselves the question, what problem are we trying to solve here? What is the issue, what is the burning issue that we need to bring this rather dangerous measure into our democratic system? And in reality, there is no answer to that because there is no problem being solved here. So in addition to the cost, estimated by the Chief Electoral Officer at something in excess of $350,000, the other one is a very practical consideration. If we have 87 constituencies, and if each of, say, 4 or 5 political parties run 5 candidates in each nomination, we could be looking at upwards of 1,300 nomination returns that require auditing. And in many occasions, the nominations happen almost immediately before the dropping of the writ. In some cases, the nomination even happens after the dropping of an election writ. How on earth are 1,300 forms, 1,300 returns going to be completely audited to ensure that whatever problem that some people feel seem to exist out there, that whatever problem is in fact detected by the excellent people at Elections Alberta? There would have to be a period of time set out whereby after a nomination contest was completed, the provincial election could not be held simply because of the required processing time for these 1,300 forms. And I asked the question, what would happen if in the process of processing of these forms, if it was determined that a nominee had in some way violated the rules within that are set out? Would that candidate then be disqualified? What if the form hadn't been audited until after the election and that candidate had now been elected? Would that candidate now be required to withdraw and resign the seat that they had won in the election and forcing a by-election? You see, these are all questions, Madam Chair, that I think are legitimate. They are all questions that very much speak to the impracticality of including nomination contestants in this bill. And so the amendment I've proposed, and it's long because nomination contestants appear several times throughout the course of the legislation, the amendment that I've proposed would remove nomination contests from the purview of the Election Finances and Contributions Disclosure Act. We should be doing this if for no other reason than it may not even be constitutional. It may not even hold up in court. In Ontario, it was very clearly stated that the state should interfere as little as possible with the autonomy of political parties. This very clearly interferes with that autonomy. So to pass a piece of legislation that includes clauses that may not even be constitutional, I think is a dangerous thing for us to be doing. But beyond that, even if we say, well, no, that is a principle we want to get into, I would urge members to pass these amendments because of the cost saving. We simply don't have an extra $400,000 lying around to hire extra staff at the Chief Electoral Officers. And the second issue is that the practicality of it is that because of the timing of nomination contests generally happening shortly before a general election, there simply won't be time for the processing of some 1,300 returns or thereabouts prior to the dropping of the writ and prior, in fact, even to the election being held. And so there would be some requirement for a nomination period, then sort of a cooling off period of maybe 3 to 6 months, while all of these nomination contestant forms are audited and reviewed to ensure that none of the nomination contestants, in fact, violated the rules, and then the election could be held. I think you'll agree, Madam Chair, and I hope members agree, that this is a gross overreach of governmental authority into the affairs of political parties that in order for our society to have a functioning democracy, we should have as little interference with the function of those parties as possible. And so, Madam Chair, I would encourage members on all sides of the House to to support these common sense amendments to remove nomination contests from the purview of the state. Thank you, Madam Chair.